All right, it's time to do some good news stories. We got one right here. Yep. I'll try to do at least two. Oh, that's right. We'll start with this one. A judge overturns a conviction of a cop who shot a black man point blank. Yeah. Yep, the judge overturns a conviction. The jury convicts this cop, but the judge overturns it. I kid you not. This is crazy.
A judge decided to overturn the ruling of the jury, overturns the conviction of a cop who shot a black man at point blank range. Here's the video.
Here it is.
All right, Pete, do me a favor, go step out. Step out for me, please.
I don't want to go.
Okay, I'm not asking you right now. Step out for me.
Why?
No.
Can I know why?
Because you're not coming back on file, man.
Hey,
Step out of the car.
Can I know why?
Because you're not coming back on file for me.
What does that mean?
Step out. You're not coming back. You can't figure out who you are.
Listen.
Hey,
What
look
do
out.
you can't figure out who I am?
Because it's not coming back on file. You better come out now, dude. Hey,
Okay.
you gonna cooperate or what?
I'm going to cooperate.
Okay. Put your stuff down. Get out.
Can you stop holding me? You stop touching me.
I don't want you reaching for anything, man.
I'm not reaching for anything. I'm not reaching for anything.
Okay, step out.
Okay. Drop it. Just drop it. I'm not reaching for anything. Turn around. I'm not reaching for anything.
Dude, stop.
Turn around. Turn around.
Hey, fun man. Stay in the car.
The black male was shot. Okay? The cop who did it, charged. Cop goes to trial. Jury convicts. Judge overturns. Let me explain what happened. So unfortunate. Put up the picture full, man.
Here it is.
A white cop with a red devil tattoo who killed a black man accused of stealing beer wins a new trial after the judge decided to reject the verdict of the jury. Presley Ease's encounter with the police turned into a deadly encounter.
You know, and I've heard instances where I heard cases like that where a jury will convict somebody like that, and defense attorney or lawyer will ask the judge to say, "Your Honor, motion is set aside the jury verdict," and they'll say overrule, and next day they'll overturn it. I've seen a couple of episodes on Law and Order where the defense attorney say, "Your Honor, motion to dismiss the jury verdict."
A white New Mexico cop with a red devil tattoo on his forearm was convicted on manslaughter charges in February for the shooting and killing of a 36-year-old black man named Presley Ease. This was in 2022, who had been accused of shoplifting a $2.39 can of Budweiser from a gas station convenience store. A state judge, however, rejected the jury's decision, granting the former cop, Brad Lunsford, a new trial. New Mexico District Judge James B. Foy claimed the evidence presented during the 8-day trial was, quote, weak in proof, essentially nullifying the jury's verdict. But now it's been revealed that Lunsford was not only texting fellow officers during his criminal trial who were in the courtroom to support him that week, including his police chief. He later deleted those messages to keep them, from being obtained as evidence for the upcoming civil trial against him. That's already a violation of civil law.
Yep.
You have a non-spoilage agreement when you engage in litigation.
That's a violation of constitutional rights as well, too.
That could be utilized against you. Now, Judge Roy ordered Lunsford released from jail 5 weeks after his conviction, where he was being held awaiting sentencing. The former cop is now sitting at home with his family awaiting a new criminal trial, as well as the civil trial stemming from the lawsuit filed against him by the deceased family. Neither trial has been scheduled. I'm going to get into the shooting in just a moment, but I want you to understand that a judge decided to override the will of the jury and said that the evidence was weak. The proof was weak. Now, a judge is not a fact finder. The fact finder of a case is the jury. They are called the fact finders. That is a legal term of art. They are the fact finders. They are the
And not only that, the fact finder is usually the prosecution or the district attorney as well. They're the fact finder, presents the evidence to withstand or try to withhold evidence.
ones who determine what your facts
They
are
present
and
the
what
evidence.
your facts are not. Whatever they say, those are the facts. And a judge will accept, they have determined these are the facts. This is why they have to weigh the credibility of statements. And if they weigh somebody's statement to be more credible than another, once again, that becomes a fact from the fact finders. And the fact finders are the jury, not the judge. So the judge decided that the fact finders were not adequate. They did not properly allocate the proof burden in this case, and overturns their decision to convict this cop of killing a man at point blank range. There's more. The shooting, Lunsford stuck his head in the store and asked the employee if Ease had walked into the store with the beer. The employee said no. The cop did not ask to see the security footage. The cop then walked back to the car where Ease was sitting in the passenger seat and asked for his name through the driver's side window, but was having difficulty understanding him, telling him, quote, "I can't hear you," at one point. Lunsford then walked up to the passenger side of the car with another cop who had arrived and ordered Ease out of the vehicle, pulling him out of the car while accusing him of reaching at the same time. The victim told him he was not, the victim told him he was trying to be cooperative. He wasn't trying not to be cooperative, wrestling, but was confused as to why the cop was grabbing him as they were wrestling him to the ground. And the other cop's taser fell off his belt clip. It landed near the victim's right hand as he held himself up for support against their weight. But Lunsford, reacted by pulling his gun and firing a single shot into the left side of the victim's head at point blank range, killing him instantly. The man is unarmed, has no weapon. They are aware he has no weapon. They have already grabbed at every inch of territory on the man to know he has no weapon. He is being wrestled to the ground, confused as to why. A taser drops. A cop takes the opportunity to shoot and kill this man at point blank range. Keep in mind, a grand jury indicted, a jury convicted, and a judge overturned it. So everybody's in agreement, including the district attorney who brought the charges in the first place, including the grand jury who looked at the evidence, including the jury who examined the facts. But one human being, state court judge, said, no. All of y'all are wrong, and the only people right are me and the cop.
Mm-hmm. And there are some judges that are pro-cop that have the attitude, oh, cops don't lie, they can do no wrong. Well, there's a reason why I got to qualify me. Oh, and just an attitude, oh, you'll just need to back the blue because only blue lives matter.
Criminal investigation and trial. It is difficult to see on the video, but investigators from the Dona Ana County District Attorney's Office said Ease grabbed the taser but did not discharge it, did not point it at the officer, may not have even known what he was grabbing, okay? This was on the 12th of February. A 12-person jury unanimously convicted Officer Lunsford. You know how hard it is to get a cop convicted by a jury?
Really hard.
They looked at the evidence, weighed it. They are the fact finders. They said he's guilty. A rarity in a state that last year led the nation in police shootings per capita.
I mean, just like a Tyree Nichols, just like a Manuel Ellis. There's a couple others where cops were found not guilty by a jury.
Yeah, according to mapping police violence. They are very friendly to killer cops. Let's put it that way. This state is friendly to killer cops. This one was quite easy for them to make the decision. This cop killed this man unlawfully. he should go to jail. He should go to prison.
Yeah.
Justice served, right? Wrong. However, Officer Lunsford was released from jail March 21st after his attorneys filed a motion. This is called the inside politics of it all. They knew to file this motion. After the attorneys filed a motion alleging several judicial errors, including the judge allowing 2 alternative jurors to replace 2 selected jurors. Judge Foy granted the motion, ordering the cops released from jail where he had been awaiting sentencing, acknowledging he had committed judicial errors during the trial. Let me talk about that for a moment. Admitting he had committed judicial errors during the trial. Errors happen. This is why you say objection.
Yeah. Objection.
Once you
Hearsay.
object to something,
Objection.
you
Speculation.
preserve it for the record to be appealed. If you do not object during the trial, the common rule is you do not preserve that thing that happened for an appeal. You can only appeal the things that
You know, it's like a lot of times you're arguing like that. You hear like a lawyer or well, if it's the prosecutor or defense lawyer, they'll say objection and like that. And a lot of times, what comes back what the judge will say, they'll say sustain or overturn or overrule. That's what it is.
you object to during the trial. That's 1. 2. Errors do not necessarily mean that it transformed the outcome of the verdict. If you recall, there are many times when the Supreme Court will make a decision and they will say, this was improper, this was improper. However, we do not believe that those improprieties actually changed the verdict because those things did not go to the matter in question or the issue at hand, which was the guilt or innocence of the accused. In this situation, this is me reading the tea leaves. It seemed as if somebody got to the judge after the verdict. That's what it looks like to me. And the judge acquiesced and fell on his sword because they're not citing that any of this would have changed the outcome of the conviction. Normally, if you get a new trial, it is because whatever error or errors have been made would have substantially changed the outcome of.
And a lot of times when a new trial is happened, it's usually because the previous trial was declared a mistrial.
Of the conviction itself. It goes to the heart of the matter. None of these things go to the heart of the matter. None of them. It's an error, granted. Did it change the heart of the matter? No. Typically, that is decided based on a rule, and the verdict stands. Earlier this month, Foy published his opinion stating the evidence used by the jury to convict the cop was, quote, weak in proof. In June, the attorneys for the family filed a motion for a default judgment in the civil case on the basis that Lunsford destroyed evidence, and he did. Specifically, the text messages he sent to the police chief, Jeremy Story, as well as a lieutenant and sergeant who were in the courtroom during trial. The 78-page motion also includes details of the corruption within the police department specifically and how the agency attempted to protect Officer Lunsford in the wake of the shooting by refusing to release evidence. It also includes exhibits like Lunsford's social media posts on his personal Facebook page and sayings like, quote, I hate vagrants, end quote. But the federal judge in the civil case did not believe the destruction of evidence was enough to impose default judgment sanctions against Lunsford. Well, proving my point again.
Mm-hmm.
That proves my point. The judge in the federal case said, yes, these are errors or outside of the accepted and appropriate conduct for a civil case. However, it is not enough for the judge to automatically issue a judgment in favor of the family. However, in the criminal case, an alleged error that did not talk to the heart of the matter was enough to overturn a grand jury indictment and the conviction of a vetted jury. So it can work against the family, but it can't work for them. Isn't that something? All right, Senator, thoughts here.
You preached a sermon, Doc. I will just say, amen. I'm glad that this family gets to duke this out in civil court. I mean, this is just stunning. And all of this, all of the 3 stories that we just did today, all of this that these people were suspected of stealing, less than $50.
Right,
But it was worth their lives. I agree with you, Doc. Something smells here.
right.
It really
right.
does.
We will bring you updates as they come.
I mean, it's crazy. I just think, like, how many times I said it time and time again. It's just like you got cops out there that value property and items over people's lives. I'm just thinking, I bet you the federal judge, he'll probably dismiss the new trial. He'll dismiss the case, and the judge will put whatever you see the family side, they'll dismiss that, saying there's none of the evidence, and they'll say, oh, that cop did no wrongdoing. It was all justified. I mean, it's like that judge probably saw only one color, blue. Yeah, the color of what the cop's wearing. He's just another dumb clown in a black robe. You know what I'm saying? All right, with that, I'm out here much. Peace out.